Today poll. Should the U.S. remain in the United Nations? State wants to be able to take your car away if you go 5 miles over speed limit. Indiana is working overtime to abuse civil asset forfeiture seemingly in an effort to pad its budget. Apparently, even the smallest of crimes such as driving a few miles per hour over the speed limit can cost the average resident a lot more than he or she expected or thought was possible. Let's go over the backstory first. In 2015, Tyson Timms was charged after he sold illegal drugs to undercover Indiana cops. He was using the money he earned, as is all too common these days, to fuel an opioid addiction. After his guilty plea, the state filed a lawsuit demanding that his $42,000 Land Rover SUV be confiscated. The problem, however, is that Tim's crimes only carried a maximum fine of $10,000. The vehicle is obviously worth 4 times that amount. The private law firm representing the state of Indiana argued to invoke civil asset forfeiture because Timms drove around with heroin for a short time. Although I'm in no way, shape or form defending a convicted drug dealer, it's more than concerning that the state thinks it's entitled to more than the maximum fine amount in those situations. It's essentially legalized theft. However, despite the case between Timms and Indiana making it to the United States Supreme Court last year and the SCOTUS unanimously ruling with Timms, the state of Indiana is still trying to argue that even the most petty instances of breaking the law can result in civil asset forfeiture. According to Reason, that includes a situation involving a vehicle that was stopped for going 5 miles per hour over the speed limit, if you ask Indiana Solicitor General Thomas Fisher. This is the position that we already staked out in the Supreme Court when I was asked by Justice Stephen Breyer whether a Bugatti can be forfeited for going over 5 miles over the speed limit, Fisher said last week during oral arguments before the Indiana Supreme Court. Historically, the answer to that question is yes, and we're sticking with that position here. Imagine the types of scenarios that regular, law-abiding folks could find themselves in, given that line of reasoning. The possibilities are scary and endless. Indiana is being represented by a man who believes a $1 million car can be impounded and sold off if the driver were to violate a driving law that carries a fine of a few $100. How does that make any logical sense? Unfortunately, this scenario has already happened numerous times around the country. According to the Washington Post, federal and state governments have obtained billions of dollars worth of seized assets because someone's private property just so happened to have a tenuous connection to a crime. But for Indiana, there are a darker element to the shady scheme. Slate reported that Indiana lets private attorneys in on the civil forfeiture process, allowing them to file claims against defendants. These lawyers make a lucrative living collecting contingency fees and some profits from the sale of seized assets. How is that even remotely ethical? The Supreme Court needs to stand strong on this issue. Hands down, this is an unconstitutional and unethical abuse of government power in an attempt to fill the state coffers and those of the lawyers who get involved. Please press the share button so your friends can see this important information. Today poll. Should the U.S. remain in the United Nations?